Y'all, we got a good friend. We're in here with a good friend, Jay Nichols. And I think Chris has probably made a reference to Jay a
yes,
time
sir.
or two on different podcasts.
So we was talking about people that's been influencers in your life, and that's Jay on turkey hunting. He's probably one of the best turkey hunters, raw turkey hunters I've ever hunted with in my life.
Yeah. So
and I think we made a couple of my buddies mad. I said, "What did you say to me?" I said, "Well,
it is what it is."
Look,
man.
Me and Jay had a couple 4 or 5 year runs. We did pretty well in a couple states, and
I probably just started taking Chris before he knew as much as he did now. Those other guys.
No, man, it was fun. It was.
So today, Jay is a perfect one. We've been trying to get him in here to talk about this for a while, and it's something that a lot of people deal with and you see around land. And Jay's an attorney.
Real estate attorney.
Like he said, an outstanding hunter and woodsman and landowner, and he's also an attorney, and he has probably dealt with, well, I just know between my friends that are clients of yours, you probably dealt with a lot of land, a lot of access issues and easements. Yeah. We want to talk about easements and landlocked properties, maybe more specifically, but those conversations go hand in hand, and that's what we wanted to get Jay in here. We got together, cooked the steak, and kind of gonna hang out and talk about easements and access.
Well, I claim him as a superior expert in easements because me and him fought one of the biggest ones that ever been fought that I can ever know about. It just had a hard-headed guy on the other side, but Jay, you had to do a lot of research on those easements.
I was going to say, before I got here today, I was thinking about the intro, what we could talk about to start talking about easements, and the first thing I thought was, a lot of, in the legal side of things, the reasonableness of the landowner whose property you need to cross is a big factor in how you're going to get across and how much it's going to cost. And we had one.
Because I know you done one time. It cost $1,500, and then I hate to even say how much mine cost.
We had one where I think both sides paid over $250,000 in legal fees to get a $1,500 easement.
That we offered the first
time.
And
had the exact same set of facts with some different folks, and it cost about $1,500 to get it resolved. But it's,
So it's like a lot of things in life. It's all about how you approach, what your attitude is going in, and the willingness of the other party, I guess.
Well, it's kind of like that old saying, you ain't guilty until you're broke. You bump up against somebody that's got plenty of money, and he's got money to fight you over it, and knowing he could lose.
Well, you know what they say about good clients for lawyers. You don't want clients with just money or clients with just principle. You want clients with principle and money, and that way they fight a lot of it. It's the principle of the thing. As long as they can pay, most people fight for that principle.
We talk about landlocked. People know what landlocked piece of property, which to give a definition to layman's term, a landlocked piece of property is a piece of property that's not accessed by a public road. It's sets off, and I don't care what county or state in the United States, every place we've ever hunted, there's landlocked pieces.
Oh yeah.
And so kind of, Jay, as far as, everybody says, oh, I got an easement, I got a prescriptive easement, or I got a,
what I hear people say all the time is, well, you can't be landlocked. You can't be landlocked out of your own property. You got to have access.
Right.
I think there's some misconception. Maybe that's oversimplifying.
Well, let me talk about it at least from Mississippi's perspective, because states are different on how they approach these things. But in Mississippi, the law will not allow you to be landlocked. And by landlocked, like Chris said, if your property is such that it does not have any access to a public road, then that's considered landlocked. Okay. And the law will find you a way to get access to that property. It may cost you some time and money to prove that access if you don't have a willing adjacent landowner that's going to let you come across his property. But and Chris, I'll let you ask me questions or stop me, but there's in Mississippi, basically there's 4 types of easements. You got an easement by necessity, and I'll talk about each one. And you've got an implied easement by necessity. You got a prescriptive easement, which I heard you mention, and then a deeded easement. And, a deeded easement pretty much makes sense for anybody in the real estate, but that's where the adjoining landowner just deeds you access across his property.
And that stays with the property no matter if it buys and sells, it stays with the property.
Yes, for the most part.
It's not specific to that owner, right?
Typically, when there's an access easement and it's permanent and perpetual, usually include that language within the deeded easement, and it runs with the land and not the property owner. Mm-hmm. You can have, and you get into a whole nother show on that. You can have an easement that's deeded that's for a specific purpose.
Purpose or
That's
performance.
temporary until that purpose is fulfilled. and
Like
the
a
easement
login or a
expires.
timber easement or
correct.
something like that.
That's correct.
Yeah.
But for access to property, typically the easements are permanent, perpetual, and they do run with the land.
Because if they didn't, then you wouldn't have access.
Then the person would have
Yeah.
problems selling it
Selling
if
it,
his
yeah.
access to it went away when he
Yeah.
sold it. So he's entitled to sell that easement too.
Jay, kind of walk through some of those ones, those different easements.
Okay, we'll talk first. An easement by necessity. That's usually the one that's most complicated to deal with. That's when you have a landlocked piece of property, and say you've got several different landowners around you before there's access to a public road. If you can't find a willing adjoining landowner that will give you access across his or her property to get to yours, then you've got to sue and you've got to ask for an easement by necessity. Of course, you've got to prove to the court that it's an absolute necessity to cross one of those properties
landowners
to get to your property. And then the issues you deal
So
with
would you
then,
sue, like for 4 landowners, would you sue all 4?
one of the requirements in the complaint is that you have to allege that you have approached and asked for permission or asked to purchase an easement or asked for permission to
Yeah.
come across all the adjoining landowners, and that all of them have denied you permission. And then, you make that allegation. Of course, you need to have done that. If you hadn't,
That's right.
you go ask them anyway.
Yeah.
If they've all denied you permission, then not only do you have to allege that you have asked all of the adjoining landowners, you got to make all of those landowners defendants in the lawsuit, because you don't know which way you're actually going to end up getting to your property. So you name them all as defendants. They're all brought in, and then ultimately, without going into the entire dog and pony show,
They'll find the best way.
the court decides which access it's going to give you to get to your property, and they try to go by what they consider the least intrusive as far as the adjoining landowner.
Yeah.
You may have one route. Typically, people think the shortest route is the best route. A lot of times that's easy, but you may have a short route, say half a mile, that goes through 4 property owners to get to you, where you may come 3/4 of a mile from another side through one landowner. And so, it's up to the court to decide which one is the least intrusive.
And I can tell you, people they're not happy with it. I mean, it just, because you're
Nobody
going.
wants you to come through their
No, and I've been down it several times, and
Been on both sides of that.
I have,
Both, and a lot of landowners have.
and I've had to roll up. Me and Jay was on one that somebody come to me and said, "Look, we got to get there to it." And I didn't want it, but I knew enough about the law, because I done paid for one, that we kind of negotiated another way in and put it in there. But I mean, there's another thing, and Jay can get into that. People say, "Oh, I'll make him go across this slough or go across this pond." No, you're not. Judge ain't gonna do it, and Jay can stop me on that. I mean,
the reasonableness standard is kind of
Right.
It's a gray area when we get into reasonableness in the law, but that gives the judge a lot of discretion. But a lot of reasonableness means dollars.
Yeah.
And if somebody says, "Well, I'll let you come across, but you're going to go all the way around the back side of my property, and you're going to go through this ditch and across this and all that, and then
you're going to build a road."
Judge, that's not reasonable access. It's going to cost me $85,000 to get to my 10 acres down here, because I got to put in culverts and dig, and you may even have to mitigate wetlands, dealt with stuff like that. And so it's up to the court, the location of the easement, but
it goes back to like you said, Jay, good witnesses to help you guide yourself, through there.
Well, you got those
It can be
easements by
tricky.
necessities. You end up
Tricky.
making a lot of people mad.
Yeah.
And there's usually problems that persist after that, because
You think
sue
about it,
everybody.
Brent. You suing 3 people that you don't want to go through to get to the one that you do want to go through. Mm-hmm. I mean, because you really, at the end of the day, where you want to
Pick the
go.
route that you want to go.
Yeah, and
But
that
you have to bring all the other ones in, and they're usually not happy about having to defend them.
No. We've had some good ones. What's the
Chris,
next one?
The second one I mentioned is what they call an implied easement by necessity, and that's one where
That
let's
just
say,
sounds like a big gray area.
Well, it's really not. You go back and you check in the title, and let's say back in 1980, let's say you got a 200-acre block that joins a county road. Well, say 2005, that owner decides he's going to sell 80 acres in the back. Well, when he cuts that off and deeds that 80 acres to somebody else, that creates a landlocked situation.
Right.
Okay. When you sell a smaller part of a bigger tract and it creates a landlocked situation, by operation of law, right then at that time, soon as that property is severed, by operation of law, there is an implied easement by necessity across the bigger
original
tract,
place,
which becomes what they call the servient estate.
Right.
To, in my example, the 80 acres would be the dominant estate.
Dominant.
And so, and sometimes when that happens, somebody may own that little 80 in the scenario I just gave you, and they may cut timber. They may have a permissive use agreement or something for a while, but eventually the issue is going to come up about it being landlocked, and they need permanent access to get to that 80, and they need an easement, and they talk to the owner, who may be a different owner by this
That's
point
what I
in
was going to
time.
say. This gets complicated when that original servient
That's
tract.
right. And so you call them up,
Sales.
and you say, look, we've checked the title, and we've got an implied easement as a matter of law across your remaining 120 acres. And, they can either believe you if they hire a good lawyer that will understand and they look at it and check it out. I mean, there's really won't be any dispute. If it comes
Black
off
and
of that,
white.
when it came off and when it created that landlocked situation, that bigger parcel became the servient estate.
And that may not be spelled out. Would they just have to look at the deeds, how the follow the deeds, and how this was
a good
parceled
title
out of
opinion
their
helps
title.
you.
We've had to go
Title
back,
history.
Typically we check title, we go back 31 years or whatever. We've had to check them on easement cases before, where we go back and find that
1800s.
the original tract may have been severed in the 30s or 40s, a long time ago.
Yeah.
And of course, that'd be part of your complaints. You arraign title, but you show, once you prove that your landlocked piece was at one time part of a larger tract that has access to a public road, then there ain't any question then. It's a little bit different. I'll get back, but you don't have to sue all the other adjoining landowners then, because you coming across that serving estate.
Yeah.
You just got to figure out where.
You proved that you were once part of it, and that when they severed it, that created the landlocked situation.
And that was the case.
That's right.
That was our case, because the tract I ended up with was 275 acres, but it was off of a 650 acre tract that had access. And the guy that bought it, he, just, I hate it for him, but
he was like a lot of people.
he didn't want you to go, and he was trying to put a big deal together, but I owned it right in the middle of him. And he had done some other things to some other landowners, fenced them out, did some other stuff. So he wasn't the most joyful to the neighbors. But I tell you this, I didn't back up. And it wouldn't have been for Jay. I mean, we that case was
difficult case.
That was a long case, and it took. I couldn't go that property for 2 years. Remember, took 2 years in court.
Let some of his deer grow up, though.
It did.
2 years when he couldn't hunt.
I killed one big deer right over there.
Somebody else killed
off
a
of
big
it.
deer
Yeah,
out there not long after.
That other landowner.
Yeah, you got that. He was on the podcast earlier. 200-inch deer.
Yeah.
Yeah.
Well, what I was going to say, one big difference, though, if you'll remember on this, on that implied easement, as a matter of law, by necessity or whatever, once you determine that you're coming across that serving estate, or once the court determines that, you don't pay for that easement. It was created literally by severing
When
that
it was
small
severed.
tract.
Yeah.
On an easement by necessity, when you sue all the adjoining landowners and the court finally decides, okay, Mr. So-and-so, I'm going to give you access across John Doe here, then you got to pay for that easement, and if it's 30 feet wide and half a mile long, a lot of times they'll calculate
Per acre.
the acreage and
You
figure
have to
out
get
what-
appraisers to go out there and appraise
That's
it.
right.
Yeah.
But you pay for it. Even at the end of litigation, the court tells you where your easement's going to be, but you got to pay the landowner for that easement, for that use. Not an implied easement by necessity.
Yeah.
It's when you bought the tract that was severed, you paid for it then.
Jay, you handle estates for people and you in family, but this would be a good takeoff, Brent, in you selling real estate. If Pawpaw's got 300 acres or 200 acres and he divides it, make sure he gives easements to the
access,
kids
the way you
or
divide
access to get it, because he's going to cause a problem. And we see it all the time, air property. They'll divide our property up, and there'll be 15 slithers and with no access.
Look, you bringing up stuff we could talk.
Yeah,
we could have
I know, but I'm just
podcast
saying,
week.
if somebody can take something away, if their grandparents or their daddy and mamas
easement.
are getting ready to divide some property to multiple children, make sure all of them has access.
You'd be surprised
Because they do it a lot and don't know
Example,
access.
if somebody dies and let's say they had 100 acres, makes it easy for me to do easy math, and they have 4 children that they leave it to in equal shares, you'd be surprised at how many people think that, well, I got this 25 acres and she gets this 25 and he gets this 25 and I get that. It's not like that. They all get an undivided 20%, 25% interest in the whole.
In the whole tract.
Joint tenants or tenants in common.
So, well, they would be tenants in common.
Yeah.
Unless they left it in a will that way, and it says if he leaves it to the 4 children with rights of survivorship,
That's
then
right.
it wouldn't be.
That's right.
But if it doesn't mention it, they'd be tenants in common. And then it.
So you talking about leaving it to 4 or 5 kids and never dividing
if you don't actually divide it.
undivided interest.
So you tell, and a lot of times the children will want to divide it up that way, as long as they agree that's easy. But that's when it comes in, like you mentioned earlier. You need to tell them, somebody needs to say, well, listen, be sure when you divide it, if all the tracts don't touch a public road, this brother John needs to have an easement across the first 3 tracts to get back to his, and Brother Jane needs an easement across the other 2 to get to hers, and our sister.
Because most of the time, and I've bought and sold tens of thousands of acres, I've never known where one tract, everybody up joins the road. You're going to have an offset 40, you're going to have an offset 80, you're going to have stair-step track. I mean, you know that, Jay. You go through them. I mean,
Depends on how you divide it.
yeah.
Yeah,
That's right.
And as time goes on,
Fragmentation,
and these
yeah.
properties get fragmented and left and divided. I mean, there's more and more opportunity for these landlocked situations, and as more and more people are buying recreational property and moving away from the city, there's more opportunity for some
Well, Brent,
people get in a bind.
Brent, tell me why a lot of people buy landlocked, because it's what?
It's cheaper.
There you go.
And look, it's
a defect in the title.
Yeah.
You can pull up Facebook right now, and you'll find 4 or 5 people. If everybody, if you're listening to this, you're probably following some land, or somebody you know is a realtor, and you'll see a listing come up. And the first thing I'll do, have that on-net. Usually there's an aerial shot or an on-net shot.
See what
and you look and see what that access is, because that's key.
Something funny. When you said the fragmentation and you get more and more issues come up, I was going to say, when I started practicing and I was young and dumb, before I got old and dumb, I used to think, man, in another 10 or 12 years, we're going to have all these property issues fixed because we run up on these problems in the title all the time, and we keep curing all these titles. Before long, everything's going to be cured and there won't be any problems. It does not work like that at all. I think
there ain't a time I come in. There ain't a time I come in. You're working on a description. You're working on
there's a
bad shot.
Title almost, of some sort.
You get. We always pick on these timber people. So anyway, but a lot of the timber people do their own deeds. And y'all
have never done that.
I pulled a little timber contract every once in a while. But Jay, and I got to say him because I love him so much. But Jay's daddy was probably one of the best real estate attorneys in the state of Mississippi at one time. When you agree, Jay?
I would agree.
And I mean to say, and he was as Aubrey Nichols was as sharp.
I'm biased though, but
I'm biased too. He taught me everything I know about titles and looking up stuff in the courthouse. He spent that time with me, and he nurtured me, and it, that gratitude to him for the rest of my life is
you do a lot of your own legwork, and you always reference that back to Aubrey.
And 100%.
You didn't have it all together.
He taught me the good and the bad, and then when I do bad, he'd get on my butt. And back then, Jay, because we used to nickname Jay Domestic Jay, because he did divorces and all this other stuff. But then when Aubrey retired, Jay become the real estate leg of the company, and which I'm glad he's doing.
He was always real detail oriented.
Unbelievable.
Unbelievable details, and it's little things, Brent, like you wouldn't think about it, but maybe 15 years ago you wouldn't thought about it, but now you're in real estate, you think now, like you said, first thing you look at, see if there's access. Well, if you've been practicing real estate law for a long time and you've run in to a lot of the hurdles that you can see, then going in kind of the stuff to look for and check, and you deal with it. But there's
talking about details. Aubrey made me rewrite an easement for a power line, for like a 5-span power line. I had to rewrite that sucker 5 times.
Aubrey was funny.
And utility easements are notorious for being vague and just enough, and Aubrey was not having it.
A lot of my deals,
detail oriented.
a lot of my deals that I would come up with, I had to do it right then. Hey, I got to go because you know, in the timber business and land, somebody's nipping at your butt to try to get that deal. And you know, I would be a little half butt sometimes on a contract or something. Aubrey would tear me up. But it's because.
Did you say used to be?
Yeah, I mean, you know.
I was wondering if he was the one nipping. I wonder who was doing the nipping.
But it's always an angle. You get an angle, and you know, that angle's kind of
right there.
Then you kind of.
Yes, you only got two hands
Yeah.
at his angle.
Yeah, but you know, having him, Jay, and mentoring and how sharp he was, it's just, you know, we learn from the best.
It helped me a lot. I can tell you that.
Sharp man, he would get in there, and I mean, went through 4 years of forestry school, and Aubrey would, you know, they always threw the section maps, but he would show me how to read the quarter section. He would show me how to read a deed backwards.
Yeah.
To figure out where this thing, you know, they didn't teach us that in forestry. They showed us all that stuff. They didn't teach us how to read that. And I mean, all that stuff is him. And anyway, I didn't mean to get off, but he's one that me and you both, and you, I mean, if you ever dealt with him, he was that sharp. He was a sharp guy and loved land. Aubrey loved land. I mean, that's the thing about him. He was
And he's still with us. He's not.
Oh yeah, no, he ain't going nowhere. He's just retired.
I started to correct it a couple times, but I thought, hey, he's talking.
No, he just
retirement.
retired. But he's. There ain't a day goes by, there ain't a week goes by I don't think about him and stuff. Just stuff he did with, you know, for me. But anyway,
So going through these easements, you mentioned one that I think causes a lot of confusion, and that's the prescribed easement.
Yeah,
a prescriptive.
A prescriptive easement.
explain that one, Jay, because that's what everybody thinks.
People
we got
confuse that with adverse.
We got a prescriptive
adverse
easement.
possession and some of the same boxes maybe to check, but that's some of.
Well, adverse possession. A lot of people have heard about adverse possession. That's an ownership interest in property. A prescriptive easement is identical to adverse possession, except that it's not an ownership issue. It's a prescriptive use, access for example. So the elements of proof are the same. Just like for an adverse possession case, if you're trying to prove that you have adversely possessed a piece of property, you got to show that you've occupied it, you possessed it, and your occupation and possession and use of the property has been open and obvious. I always get
hostile.
I get tickled at the elements because one of them's hostile and one of them's peaceful. And I always scratch my head and think our legislature
hostile and peaceful.
This. It's got to be hostile and it's got to be peaceful. Well, hostile means that you're claiming that it's yours ownership, that you own it. It doesn't really mean physically hostile to anybody. And peaceful means that any other owners over there have not challenged your ownership or done or said anything, not sent you a letter saying, hey, Mr. Herring, you don't own this property. You're encroaching over on me, yada, yada, yada. That would be, you know, that's what the hostile and peaceful means.
That's
and it's
the standard for peace. Yeah.
And it's got to be uninterrupted for 10 years or more. And a lot of people don't know. They think that, well, if the person before me owned it for 8 years and they sell this property to me, we're talking about an easement now. You know, if I own it for 3 years and have been using this easement, you can combine the years. It doesn't have to be 10 years under the current ownership. It just has to be 10 uninterrupted years of use,
continuous
possession,
and open.
claim, and claims that it's yours.
And that's if you're landlocked.
No. You can get a prescriptive easement even if you're not landlocked.
Doesn't have to be the only access.
If I had 50 acres that joined a county road on my south end, but I come driving through Brent's property on the north end, if I cut across 80 feet corner of his property on a little dirt road or path that I cut, and I do it for 10 years, and Brent never says, hey, stop using my road.
Or you have permission.
Or if he gives me permission, it stops it.
That's
but
right.
I mean, but if I do that, and then let's say I've done it for 10, 12 years, okay, and then I sell my property to John Doe. John Doe buys it and starts using that, and then Brent says, hey, man, you can't use that anymore. Stop. Yeah. He says, I got a prescriptive easement. Brent could say, well, you've got access over here, this county road. That doesn't matter. If it's been 10 interrupted years of somebody using that and the correct title owner has not stopped them or given them permission to do it, you can acquire a prescriptive easement. It's the same elements of proof as adverse possession, but being landlocked is not an element of that.
Yeah, but the thing about
that's why the term necessity you don't hear used in a prescriptive easement.
Right.
You got easement by necessity and implied easement.
That's a good point.
Necessity.
But it's not going to be anywhere on paper. That's the thing about it. That for
It's
me,
not a
like
deeded
on some
easement.
properties that I've listed and sold, it's not, people want to see,
Until
a
it's
deeded
established.
easement or something, some permission. And I this one in particular, I because of all those, it met all the standards. I said, look, this checks all the boxes for prescriptive easement. The previous owner's been using it, 3 decades this way. There's several other landowners that use it, and they mentioned, well, maybe I'll just go and ask for permission. I said, you don't want to go ask for written permission because that's a license, and a license can be revoked.
That's correct, and
Yeah,
that could
and
stop
so
the uninterrupted tenure.
That stops that uninterrupted. It's not. It's so you in that situation you continue to use it, but you may, if it's challenged, then you may just have to go to court to
Well, you go to
establish. The
court
judge
to
would establish it, right?
That's correct. You go to court to prove it, and the way that you usually see that happen, if somebody does have a prescriptive easement and they've been doing everything and they've met all the elements, and then the landowner puts a gate up and says, "You're not coming across here."
New landowner. That happens a lot with new landowners.
That's right.
And they say, "Look, man, I've been coming across here for 27 years. You can't stop me now. I've got a prescriptive easement." And they can say, "Well, you're not coming through here anymore." Well, then you sue, and you go to court, and you prove your elements of the prescriptive easement. And assuming that you win, if you prove it, and the court grants you that easement,
And 4 or 5 elements you were talking about.
yeah, then the court can either order the other property owner to convey you an easement that's described in the court order, or if you get ready to sell your property that you got that prescriptive easement to, you just sell it, and in your description you'd say, "Together with and including an easement for ingress
Down
and
an old
egress as set
road.
forth and ordered in Chancery Court, cause number, yada, yada, yada," and
That's
you
pretty
reference,
cool.
you can record that court's order
So
in the
then
land
does
records.
it become a deeded
It's-
easement? It's
yeah.
no longer prescriptive then,
Well,
or is that
if he deeds it to you, if the court requires the owner to deed it and do you a deed, then it's a deeded easement.
Right.
If the court just enters an order granting you that easement, the court's going to have to define in the order where that easement is, and you can take that court order and record it in the land records. Okay.
And it attaches to your deed.
So, and instead of having a quote deeded easement, like I said, if you got a prescriptive easement, Brent may sell that property to Chris, and he sells it to Chris with the property description, and then it would say, "Together with and including an easement for ingress and egress
Right.
as set forth in court order in the case style this, recorded at book page this," and then somebody can flip back and they see that order's been recorded in the land record. So it's a recorded easement at that time. It just didn't come from a deed. It
Right.
came from a court
Okay.
order.
And Jay, they can get squirrely. I mean, we're hung up on one in Alabama right now, an old county road. Went up through there. You described it up through there, but there was one landowner that it went through. Well, when they run the title, when they wanted the title insurance, and they wouldn't insure it because they said it doesn't matter to me. It looks like a county road and smells like a county road, but it ain't on
the county had abandoned
the
it?
county had abandoned it.
I was going to say, you just brought up another issue that causes a lot of problems
Yeah.
now. Is you got a lot of county roads, and abandonment of a county road is really illegal. It's a term of art. It's a legal issue, and a lot of people think that, well, if the county hadn't been out here maintaining this road in 20 years.
Don't matter
Physically, they may have abandoned it. Legally, they haven't.
unless they go through those steps.
Yeah, you've got a list, and I mean, you got the
Go
board of
through the board of
supervisors.
supervisors.
Just stop grading it.
No,
There's more to it than
They
that.
may have physically abandoned it, not do anything, but it's still a county road unless and until the board of supervisors has to give notice to all the landowners that use that county road and their intention to abandon it and not maintain it anymore. And they have a hearing, and all the landowners have an opportunity to object. But if it's formally abandoned, it's on the minutes of the
Board of
county
Supervisors.
board of supervisor minutes.
We got in that. I seen them open one up. It'd been closed for 30 years and had a gate on it.
There's a
And y'all-
lot of them
and
in
y'all
Lowndes
opened it
County
up.
like
Yeah.
that. And a lot of times it's,
I know. I'm thinking of one right now.
Yeah,
They
you know
didn't get no
exactly.
back-
No, they couldn't.
know some right down.
Yeah.
But
But,
yeah, the
a lot of time those old county roads, and y'all explaining to some of our listeners, it may only service 1 or 2 houses, but if you can prove that the county graded it, a school bus went down. Remember, it had some little things that we could prove. It had a mail route. You could prove it was an old county road.
the county is supposed to
Have a road
a
map.
county road registry.
Yeah.
And all of the roads that are county roads are supposed to be registered in that county.
And they have
road
a
registry.
distance
and
on
they've got it where they start and where they stop
Yeah.
and what the distance is for that road. So, I mean, you have cases where somebody said
We got on one,
people
Jay.
put gates across the
Hey,
county
we
road.
got on one time in Clay County for one of Jay's clients and one of my clients, and it had a start and finish. Well, when we followed the road out, it was a swamp. It was a slough and everything else, and the road went right through it.
It
was
went
like,
way further than everybody thought it would.
yes, and we had to get it surveyed. Remember?
Yeah.
And had to get a survey to mark the end of it to service it because he was having some trouble with some adjoining landowners. And
Yes, I'd forgotten how many people we sued over easements in county roads.
dude, that's why I call him the easement expert. There for about 2 or 3 years, you probably did 10 or 15 easement cases. I mean, I would just handle them and doing them. And one good thing about Jay, it's like he said, and he nailed it right off the bat. The landowner you're having to go across can make or break the thing.
So to clear up, to just give a little more detail on the example you just gave, our friend, his property started there. There was no other. He wanted a gate right there, right?
They had him blocked.
I thought he wanted a gate somewhere, and the other landowners claimed they wanted to keep using that road.
Well, that was on another end of it, and but the one that we're talking about,
down here.
yeah, they had a block, had a gate blocking our landowner, and we had one playing gatekeeper. You know him, you know what I'm talking about.
do.
He was playing gatekeeper.
He was a gatekeeper.
And probably in retrospect, he's probably pretty safe because he kept all the riffraff out. But he was giving mine and Jay's client, and our client had at the time, 500-600 acres in there. And he was giving him, it's on a county road, it's abandoned. So we went to that road register, and man, it went way off. Remember, it went plumb that we never even dreamed across other properties. And then when he saw where it ended, because it ended way in the middle of him, I think he kind of said, "Hey, let me give y'all some keys. Let's get off this." And but yeah, that was some. And Jay, and another thing, rolling back, I remember your daddy made me do something, and it makes perfect sense now. 20 years ago, I bought a piece of property that some people were going through on one end, and he made me send them a permission letter. When I bought it,
Because it can be
he
revoked.
said he
Now
told
it
me, he
can
said,
move.
Chris, he said, I'm gonna type you up a permission letter to keep in the file, and we're gonna certify, mail it to the ones using it. And I was like, well, he said this.
And they're usually
Believe me.
thankful to get it.
Yeah.
You know, so okay, well, he's letting me have
But
permission.
but
That
what
cuts off any of
but
their
what Aubrey did was
potential claims.
stop.
he stopped that 10-year click,
Yeah.
click, and
Yeah, because
You know.
that unchecks that standard.
Yeah.
Now you've got permission. And,
And-
one of the standards you have to be
and
using
people out
without
there,
permission.
if you're listening and you're thinking about some of these things, and I know they are, hey man, there's a farmer uses our road all the time to go in there and farm 80 acres on somebody else. You may put a little permission down there. And because, I mean, like you said, that 10 years, and different states are different in Mississippi, but the 10-year thing is pretty.
You send them a certified letter. You don't even, it'd be nice to talk with them, but you don't even have to. You send a certified letter just confirming that the road that they're using is on your property.
Is permission.
And confirming that, you know, you've been seeing them using it and that you don't have any problem, and then they could continue to use it with your permission
And a lot of times people don't catch that
send
part.
it, and then
yeah.
keep that letter in your file for
Yeah.
the future.
That's cool. You know, Jay, when people say the prescriptive easement, and going back to the prescriptive easement, because that's probably the most popular one, you know, and easements change over years, right? People plant trees, and so the easement will turn here, and the easement, and then I'm just going by things that we've gone up against. Beaver dams form, and
Yeah.
people get to
Water-
there, and they
water's
go
taking its
around them.
course.
And, I mean, those kind of things kind of get tricky, don't they, as far as...
They can. The trickiest part on prescriptive easements usually is over the course of 10 years. Most of the time they've been used for more than just 10 years.
Right.
And then you got to go back and you got to find the witnesses, and you got to find a landowner that owned it maybe say 17 or 18 years ago. When you talk to them and say, did y'all use this road? Oh yeah, we use it all the time. And then, you know, well, how long did you own it? Well, you own that property for 6 or 7 years. Okay, well, you got 6 or 7. Then you got to tack on some more, and you talk to the next owner. Well, yeah, I used it too. Well, did you have permission? Well, yeah, and, you know, I talked to so-and-so, and he gave me permission. well, that's not what you want to hear if you want to prove it. But finding all the witnesses, because I can promise you, somewhere in the chain, somebody that owned the piece that you're coming across is going to say, I gave permission to them to come across when they bought it.
And that stops that hurts your case.
And you have a lot of he said, she said, but that's why I was telling you, write that letter, and then you have it. And
then you
got to say, well, I gave them permission. They said, no, you didn't ever give me permission. Well, as a matter of fact, here's a letter we sent in 2003.
Yeah.
Telling you that the road is on my property and that I didn't have a problem with you using it and giving you permission to do it.
Yeah. It's some funny things because we hear, Jay, get back on adverse possession if you talk a little bit. We always hear about adverse possession. Old fence lines. Mm-hmm. That's the best. That was Granddaddy put that fence up there and old fence lines. Kind of get into that a little bit as far as because you brought it up.
What you see a lot nowadays, of course, surveying equipment with GPS technology stuff is a lot more accurate than it used to be.
Pulling the old chains.
But also back in the day, whatever, in the 40s, 50s, 60s, you go back a bit and people putting barbed wire fences up, running cattle or pastures and whatever they had. A property line is going to be, like a meets and bound call. It should be hopefully or whatever the line is. When somebody goes to build a fence on that line, they out there with their post hole diggers and
Kaiser blade,
and barbed wire, and they're rolling out and putting it up. And the chances of them putting the fence right on the line are slim to none anyway. But a lot of times there's trees or hedgerows or something like that. And so, they're not going to get in the middle of a bodock hedgerow and try to put fence posts and do. So they say, well, I'm going to, move this fence right out here. And they put the fence up there because that's the easiest place to put the fence. And so that fence stays there for years and years and years. Well, property owners change, children get it, whatever, they sell it. And then some new owner comes in nowadays and has it surveyed, and they say, hey, your fence is... My property goes 12 feet on the other side of your fence over here, and it's 27 feet on the other side of your fence down here. This fence, you're on my property. You need to move that fence. Well, then whoever put the fence up in that property, that chain of title, usually will have an adverse possession claim. And they say, well, look, we put the fence up in
1960
in the 60s, and it's been there, and we've run cattle on this farm all the way up to the fence for 40 years. We've maintained the fence. When trees fall on it, limbs fall on it, we fix the fence, we repair the fence, we bush hog, we mow, whatever you do. And showing that the fence generally has been accepted as the property line.
So even a new survey, that the fence would hold up even past a new survey.
Oh yeah. But now you can't just go stick a fence up over on somebody's property and not do anything. Remember we were talking about those elements, the open and obvious, notorious.
Yes.
You can't come down there by my house while I'm not down there and stick a barbed wire fence through the woods and never come down there and never do anything. But if you came down there and cleared a 10-foot path and put a fence up and planted a garden over there, and that's kind of some notorious and open use.
I remember your daddy.
But bush hogging and running cattle and doing all
your
baling
daddy
hay.
Told me one time, he said, Chris, the hardest land to claim adverse possession on is timberland. Aubrey always said that. He said that's one of the hardest ones. He said because you cut timber every 25 to 40 to 50 years, and he said it's hard to say, oh, them trees, I knew them. And Aubrey's also saying
do it with the pine plantation.
That's right. That's been cut.
You planted it.
Or painted line.
Planted.
Cut it.
Painted. And then thinned it the first time in 16 or 17 years.
But as far as just raw woods, and I'm dealing with one up in Fayette County, a client of mine in yours, what I'm talking about, trying to find landlines. And man, I'm in the middle of nowhere up in them mountains up in Fayette County, Alabama. And all the timber looks the same. And there ain't no corners.
Is say that you've hunted it all this time. And, you can put deer stands on it and show that you got deer stand, that sort of thing. But there really not any continuous use in hardwood timber.
But farming and hay and fences and maintenance, that proves that. That proves that fence.
That kind of stuff.
Some of those places, the only oak tree that may be in there was on that old boundary line. It's been clear cut.
Barbed wire fences growing in the middle of some other things, isn't it?
Yeah.
And boy, I tell you what, it can get into some. It could get into some funniness, that adverse possession. You know what I'm talking about? If somebody's farming or running cattle on a 2-acre field and had the fence, Well, you can't claim their whole 20-acre tract. You can only claim
Just that
where
part.
yeah. And people get funny about that. It's
Chris,
a little weird.
If you got some big property though, big property owners that have fences, old fences on it. If you got big hardwood timber, if that fence is 30 feet off of the property line, but that fence runs
Straight as an arrow.
7,000 feet this direction, and it's that 30-foot gap, 7,000
times
feet
7
long.
acres.
That's a lot of
It's
acres.
full of oak trees that big around.
A lot of money.
And your neighbor comes over and cuts that strip of timber. You know, I mean, may not be a whole ton of money, but
Yeah.
you know, you're not talking about a couple $100.
It's enough to argue about.
Oh yeah.
You know, it's enough to argue about.
Yeah, and so that's a pretty good point to make too. You reference the meets and bounds survey, and if people don't know, that's that language in the deed where it's referencing cause and degrees and distance, and a lot of those will reference a tree. You know,
Witness
corner,
tree.
and so
Yeah.
so those things
rock
change
pile.
too. A rock pile, or
Greater
like an
blade.
oak tree, and so
Yeah.
you still see some of that in some of these old descriptions, these meets and bounds
But
surveys.
man,
And those what you call, Brent, those were called monuments, and you go
That's
to
right.
a monument, a recognized monument, and a lot of those old recognized monuments don't
gone.
exist anymore.
that's right.
Yeah, and whether
Because
that's
as landowners
a tree or a
change,
tractor
that's right.
axle, there'll be an axle. There's a lot of axles.
A logger's gonna hit a corner every time, or push dirt over it.
Go to the center of a creek. The center of that creek 60 years ago may not be where the center of that creek is now.
He's right.
That's a
about
whole
that.
different legal deal
You,
there.
you remember that bonding deal? One of our landowners, Jay, handled it, him in Aubrey, and she had a deed to 60 acres, but it was the center of the creek. So a guy wanted to buy it, and it was 160, Jay. And the guy wanted to buy it at the center of a Bull Mountain Creek up in Etowamba. So he said, we agreed on a per acre price.
acre price,
And I said, because I did it, because we didn't know. I said, I don't know how many. I said, but here's what we'll do. We'll get it surveyed, and we'll use your surveyor. He said, okay. So she had a deed to only 160, but it read to that creek. Well, he surveyed that creek change, 239 acres.
because the center of the creek.
And when I
down.
called him, he flipped 2 flips backwards. Oh, boy, it's bull crap. Da, 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 da. I said, your guy surveyed it.
It all works
And-
out.
and you know what? He paid him.
because he owns to the center of the creek.
Because that's
He's
right. It's a
gaining out of
puzzle
it.
piece. And
That's riparian rights.
Yeah.
That's right.
They call it with creeks and stuff. But it's
but they change. I mean,
Well, we had one buddy, got a river on a county line. It's the county marker between
Oh,
the two
yeah.
counties, and
Yes.
it used to
Yes.
turn like that.
I
so it
forgot
had
about that one.
peninsula. Well, it blew it out.
he got property in 2 counties.
and 2
now?
counties
blew
with
it
one
out.
deed, Jay.
Yeah,
Aubrey said it was good still.
It would be. Well,
Yeah.
you know what? They're in the same state.
He said they go by the
If it was
old.
the state line had been an
Yeah.
interesting issue because if the states had conflicted.
But what Aubrey
I'd never seen
said,
that happen before.
he said that you don't go by the active creek, you go by the old. And he also told us to get your tail down there and put signs and paint the old creek bed.
Well, it depends
And-
on if you're
yeah.
gaining or losing.
Right, that's right. So many times that is.
And our guy was losing.
I've thought
Yeah.
about that. It's funny you say that, but
I forgot about that, Brent.
through this
Weird.
discussion, I've thought about that. So you really got different perspectives on this, and depending on where the listener is and all this, your takeaway is a little different. Even in the easements, you could be the guy that somebody just bought the tract that is landlocked that's next to you, and so you whether to work with the person or not, and or you could be the person looking to buy that tract because it's a good deal, but it's landlocked, so you need to be informed and know what you're getting
The
into.
protection piece is it worth you buying the landlocked property to protect somebody else outside
Yeah, if you
influence
already-
from buying it and forcing you to let them in? Because look, they
That's
always
at the
go
heart
to the
of that
good road.
That philosophy, everybody
Yeah.
said that land's worth the most to that neighbor, and that goes to that.
Could be, yeah. You see a lot of it. I mean, you still see a bunch try to
Oh
fix
yeah.
them. Yeah.
Oh yeah. I bet 2 or 3 times a month I get calls
About landlocked
with
stuff.
landlocked situations and what to do.
That, Jay, there was another easement that you was talking about. I guess the deeded easement was
A
the
deeded
last
easement.
one, and that's a pretty. Kind of tell them what that
Yeah.
one, and it makes
Well,
sense.
And well, if we're starting with a landlocked piece of property, you go to your surrounding neighbors and you find one hopefully that's willing to let you come across them. Usually, most of the time, there's a driveway or something that already exists, but for anybody that's listening and wants to find the easy way, you go talk to your landowners and tell them, look, I'm looking for access to get through here, and the least intrusive way, and I'll pay you, and it's cheaper.
That's the key. Pay 'em.
That's what I said about people being reasonable. If they understand, especially if there's only one landowner blocking you, you know what I mean? If you're backed up, if you're surrounded by one landowner, he or she has got to understand.
He got to let you in.
You're coming through them. And it's going to be cheaper on them to find a place to let you come through that's reasonable access and let you pay for that access and let him pick it, so long as it's reasonable and doable, and then get paid for it. Because a lot of times they want to dig their heels in and they say, "You're not coming across me. I don't care what you say."
A lot of people are hard-headed.
And you try to tell them, and I've had to tell them before, listen.
You're going to lose.
He's going to get in. It's just a matter of where. So we'll work with you and you pick the location, and as long as it's semi-reasonable, that's fine, and we can agree on a reasonable price. And, like we talked about when we first started, we had one of those, and $1,500 in, it resolved because the parties were reasonable on the other side, and they understood.
Talked about it, and they get along good to this day.
Yeah. And
now, me and that guy, we ain't spoken years.
And that brings back up what I mentioned earlier.
Bitter.
When it's hostile to begin with, even if you get the easement, there ends up being problems down the road, usually because there's that bitterness there, whatever. But if you're reasonable on the front end, you usually end up having good neighbors that help each other. And so,
Jay, you brought up one pretty cool thing that me and Brent was both talking about. Kind of explain what you're talking about, the creek or like a piece of property.
Right.
Well, no, just say you got 100 acres. Let's keep it easy. Big creek runs down through the front side of it. You got 5 acres on one side of the creek.
Okay.
You got 95 acres on the other side of the creek, but an access
on the 5-acre side.
That's right. You got access on the 5-acre side. Big creek.
So you're not technically landlocked.
That's right.
You are cut off.
But your 95 is cut off, but there's a road over here that gets fairly close to yours, or
you can. That's when you get into that term, and we've used it here tonight several times, that reasonableness. And that's when you ask the court and you say, "Judge, I need an easement
365
by necessity." And one of the elements of proof is you got to prove that you're landlocked, you got no other way to it. So the other side, their quick defense is going to say, "Judge, their parcel's not landlocked. They've got a road over here that touches this tract, and they can get there." And then you respond and you say, "Yeah, but Judge, that road gets me to this 5 acres. There's a creek that cuts that 5 acres off that's 60 feet wide and 30 feet deep. And it cuts me off from my other 60 acres, or ever how many you said."
Yeah.
You get into that reasonableness then, a reasonable necessity instead of an absolute necessity. And the judge can say, and you say, "Judge, I could come across this way. My 60 acres is worth $2,000 an acre. It's worth $120,000. It's going to cost me $150,000
to build a bridge,
across that creek that's going to give me reasonable access to my property." And the judge, should say, "That's unreasonable. We're not going to make you do that." And then he'll let you come across somebody else on the other side.
But you'll have to pay it probably.
You would. Yeah. You'd have to pay for the easement.
Pay for it easy.
Yeah.
And we've mentioned that a couple of times, and there's probably some misconceptions around that. Like, there's an like you may have to pay. This isn't a free access or free easement. It's not just your legal fees if you have to go sue for it. But you have to compensate that
for the actual access. Yeah, the two kind that you don't pay: the prescriptive easement, because you prove you own the rights to the access,
right?
Over the 10 years, and the other is that implied easement by necessity, when you have that dominant tract that's broken off of a serving estate, because that's created as a matter of law as soon as that smaller tract is severed, and you don't have to pay for that. But anytime you're having to ask the court to go over somebody else as a necessity to get there, whoever you go across, they're entitled to be paid for that easement, and the easement needs to be described. It'll be a 30-foot wide strip of land going along whatever else. And then, so usually, like Chris said, you'll have an appraiser, or somebody will have to give a value of the property. And that can include more than just, Brent, if you get into, sometimes it's not as simple as this property's worth $2,000 an acre, and this easement end up calculating 1 acre, so it's $2,000. You may have an easement that goes across it in some way. If they can prove it diminishes the value of their property,
that's where experts
by having
come
somebody come in there. And if you got some really good proof, and I can't think off the top of my head of a good example for it, but
no, but remember that? Yeah, on ours over here, they had experts come in, say the hunt was going to be destroyed. They was going to have
But they lost.
Yeah, they lost. But
That's not a good example.
Hey, but they look, man. They threw in. I mean, they had
expert
wildlife
price you on
biologists and all this stuff. Remember that? And they had those guys, and they would tell, "Oh, the deer's going to be the influence, and we're going to have a hunting." And Jay asked one of them, said, "Well, what about that county road?" And he said, "Well, what do you mean?" He said, "It's already a county road on the road register." "Oh, that's a county road?" He said, "Yeah."
People drive down that every day.
Yeah, then I had a cemetery. And then I remember one of y'all got on them and said, "Oh, you trying to tell me that a funeral with singing ain't going to bother the deer?" So, I mean, it kind of got comical. But there again, I mean, we spent 125 on our side and they spent 250 losing. And it just it wasn't a.
That's good for the lawyers.
It wasn't. Listen, it was.
We
tough.
worked on it a long time.
We did. And see, it used to go, and I don't know about other states, Brent, but it used to go to the Board of Supervisors. Remember that, Jay, before it went to Chancery? So they changed the law in Mississippi in 2001 that it goes to the Chancery courts now, but it used to go to the Board of Supervisors. You talking about
the issue of
yes,
county road.
no, I'm talking about the issue of easements. The supervisors used to give easements to the landowners because Aubrey did my last one, that one over there on 82. We did the last one in the state of Mississippi before they changed the law. But to say you'd have to get two supervisors that's not in that district to come out. They say it's landlocked. You went through the steps, and then the supervisors gave you an easement. I still got one on that.
Got the Clay County property?
No, that's a track I got out by the bypass, like going to your grandma's old place on the side of the bypass. Remember the one I'm talking about?
Yeah.
And I still to this day got
That's
that
the one
easement.
where you kill one turkey on every year over there.
Yeah, always under the limit.
Yeah.
But Jay,
You killed a deer over
let me ask, and there's a lot of landowners that lease land that listen to us. Tell them about the old timber companies that warehousing them. They build roads through their property, through other properties, and everybody uses those roads. Mm-hmm. Okay, I will say their names: Weyerhaeuser and International Paper.
Yeah,
a lot of those big landowners. But see, they won't hardly give you an easement. Mm-mm. They'll give you they'll give you permission. They'll let you use it.
Yeah.
They'll let you
revoke it.
Go across it, and they won't deny you, but they won't give you any legal.
that's where you see those gates with 7 locks on them.
They'll give you a lock. Yeah.
Yeah.
They and locks and let you come because they want you to be good to them.
And Brent, this,
but they also want to be able to sell their tract.
A bank
having 20 people have easements.
Jay, why won't a bank give you money on a landlocked piece?
Well, here's the banks. More number one, because prices are going up. Why Brent got in real estate business?
That's right.
Make all that money.
That's right.
But so big loans now, the banks want to make sure that they got good collateral, and so you check a title on a piece of property. If it's landlocked, that's a defect in title. So one of the exceptions to title, we'd know this property's landlocked. Well, usually now because the loans are bigger, the banks want title insurance. They want a loan policy.
Yeah, risk mitigation.
Yeah, so they want a loan policy, title insurance on their loan for the bank, the amount of the loan. So we can write that policy, and as an exception to title, we say, but it's landlocked, so that if you end up having to sue to get access, title insurance is not going to cover any of those expenses.
Or if the bank,
so the banks then say, hey, if we can't get title insurance to, if they're not going to insure over that exception, well, we're not going to make the loan.
Because if they foreclose on it, they'll have to sue the landowner to get to it,
or sell it to somebody.
And they won't
else,
insure it because it wasn't like a latent, it wasn't a hidden detail.
Man, and I'm
clearly
gonna tell you,
landlocked, so insurance is not going to cover that. The
That's
insurance,
right.
Jay,
Well, it'll be one of the exceptions to coverage in the policy when they issue the policy.
I've been in this business since 1997, so bumping on 30 years. And 20 years ago, you bought landlocked properties all the time, bank give you money. They didn't say a word, but things now have changed. You can't, look, we're dealing with one now that we're going to have to put up, I'm going to have to get a client. He's going to have to put up another piece of property to buy this one because the bank won't borrow any money against it because it's landlocked. Now, he can fix it.
The property for collateral.
Yeah, for collateral. He can fix it. He's going to fix the title on it. Fix the, whether
Borrow
he
against another piece.
Yeah, but he has to borrow against another piece because that piece, it could be $1 million piece of property. The bank won't let you borrow $100 on it because they can't get to it. And that goes back to what you were saying, Brent, that there a lot of times those landlocked tracts, if they had road access, they may be worth $3,000 an acre, but it's landlocked and it's for sale for $1,000.
On Facebook for $1,100.
For $1,100.
Yeah.
And the fight is like Jay said, there's no way, Jay, and unless you tell me this, there's no way.
Teddy's taking advantage of Jay.
He's feeling that steak. But there's no way that a client could come to you and say, Jay, I've got a landlocked piece of property I want to buy. How much is it going to cost me to get that easement?
I say, I have that happen all the time. And
Yeah.
I say, well, I had two cases with the same facts about 4 years apart.
God, why we got to use me in one of them?
One of them cost about $250,000, and the other one cost $1,500. So somewhere between $1,500 and $250,000.
You get in.
We'll quote our buddy Bronson Strickland. It depends.
It depends. Yeah. And I mean, it's just a lot of times Jay reaching out to them, but I'm gonna tell you now, a lot of these good hunting tracts, nobody wants you in there.
Yeah.
I mean, they like you said, they've guarded it and just say it's been our property. It's been our property for the last 45, 50 years. Well, we go in there and clean it up and buy it. Now it's occupied. So people that had been using it or protecting it, now you got invaders coming in wanting to use it that own it. You know, and it's a fine line. Look, I lease a lot of land. A lot of times people that lease land sometimes think they own it when they really just lease it, you know, and or control it.
You were talking about that cost, Chris. Out for people listening, they need to understand that case of yours involved dadgum nearly every potential.
They
legal
pushed
issue
us to
with
do
the
it.
easement.
Yep.
And one particular
They pushed
we
us.
talked about. You wanted to go through. There was a county road. We'll talk about this one.
Yeah.
The county road goes to the middle of your adjoining landowner's property, and you bought a piece which years ago was severed from his tract.
Right.
So we allege that implied easement by necessity. And like other lawyers, and you know, in case that didn't work, which we thought it would, we also asked for an easement by necessity and named the other landowners around, whatever. But, you know, our first theory was that your tract was severed from a larger tract, and therefore yours became the dominant estate, and we were going to go across the main defendant that we engaged with.
Yeah.
Period. We ended up winning.
Now let me stop it. I went to the guy 3 times.
And
I didn't
offered to
I ain't
pay.
never sued a man in my life. I went to him and offered him big money to go down in hedgerow. Didn't try to go through the middle of him. I had rights to go through the middle of him, but I said, look, I will go down a hedgerow and I'll build my own road. You remember that?
You offered him way more than what the easement would have cost you.
$25,000 what I offered him. I remember.
And to not go down the county road that we could prove was a county road, and not shoot 300 yards across
Through his
his
green
line,
fields.
but would go
Yeah.
build, and Chris would build his own road
Yep.
along the property line and go down and access it. The guy didn't want to do it. But another issue I was going to say he brought up, like you mentioned earlier, he went all the way into another county that joined the property on the backside and bought from
100
another
feet.
landowner a 100-foot strip that joined a county road, and then argued, we'll give you an easement over this strip. You're no longer landlocked. You've sued me. I own this, and I'm giving you this easement over here. You got to come this way. Well, then we got into some of the costs. I mean, because you
And
hear people
wetlands.
listening to this, frightened to death, thinking, "Man, it could cost me $200,000 to get me." But you know, we had bridge, had to get experts on
Engineers.
what it would cost, engineers involved, what it would cost to build a bridge, what
Get
kind of
utilities.
bridge.
Wetland
'Cause we got
mitigation.
wetland mitigation, but we had pictures. This big creek down there would flood every time a big rain event, and I mean, you couldn't. It was bad.
That's when we got old buddy, me and old buddy Coates got there. And Coates, pretty good size old boy. We got in there, we put hip waders on, and we walked. Now, you know, I kind of ducked down a little bit more deep in the water. That's Judge, I'm actually 6'4", but I mean, it was water that deep.
Yeah, I mean, and so, you know, we got into that argument, Brent, about the reasonableness of this other access.
Yeah.
Again, well, is it reasonable? Because we're going to have to put a bridge in that our expert said it cost $250,000.
And they put a
bridge in.
$7,000 one
And they're
in.
like,
Yeah.
no, it's $7,000, that'll work. And we're like, well, how are we going to haul a 40-ton log truck across that bridge? You know, and Chris, why'd you buy the property? For the timber. which was true.
Yeah.
Part of it.
And hunting.
Yeah. But I mean, and the judge ended up, ultimately, none of that really was involved in the ultimate decision because we ended up being right about
On the
having
law.
an implied easement by necessity because it was cut off. But they brought all those other defenses up, and you have to try them all.
Man, they had folks
and
over
it
there.
went for you. We had all kinds.
And you started out offering 25,000. You
And
build
you know
the
what
own
they
road.
got?
Zero. And you know where the road
for it because we got the county.
You know where the road? You know where the judge gave me the road?
Off County Road.
No, right down where
you're gonna
asked
build.
for.
Where he said he would build his own.
Yeah,
Yeah.
and offering 25, and that goes to that hard headedness. I'm putting my feet in the ground. I got more money.
And so that goes to, I know we've drifted some, but that goes to a point like, is somebody just strong enough to block you?
He can.
Like
yes.
if
yes.
I mean that
Jay, you know it well as I do. They can, a man with more money and a guy that don't have the money to fight it. If that would have been my daddy, just a common guy, cut meat for a living, had 40 acres in there, he'd have railroaded him, and he couldn't beat him. He couldn't fight him to beat him.
Well,
Because the lawyers.
that's the part that's frustrating.
That is frustrating. I mean, that would be, and I've always thought about that.
it's the cost to prepare the case
Right.
the way you need to prepare it. I
Yep.
mean, you could just have an attorney that says, look, if you say, I can't afford to pay any more on this, let's try it. You just go in and
It's
try it.
tell the
and
judge
hope
and
for
see what
the
he
best.
does.
But here's the thing, though. You got to remember, on a case like that, you getting access.
Yeah, you just got to figure out where.
And, I wouldn't put it past, I'd suit me if you were my client, if your daddy was my client, I wouldn't mind putting him on the stand and say, Judge, I can't afford to pay any more for this litigation the way it's going with them having 17 experts from game biologists to construction engineers and all this stuff. But I just need access to my land, so you tell me how I get there, and I'll be happy to get there.
And that right
He
there
gonna
goes a
get
long
there.
ways.
Yeah.
Yeah, I mean that. But the other side, and I guess I'm that person.
Should have put Bill on the stand.
I
Saved you a
should
lot of
have.
money.
I should have deed it to him. Let put him on there. But a lot of people could take the mental. I'm telling you, it's the only lawsuit that
He
I've
made Chris
ever
mad,
been
I
in.
can tell you.
I'm telling you.
But the mental-
you got a nerve.
The mental anguish of it is y'all. If you've never been in a lawsuit, I don't wish
Don't
on
advise
anybody.
You know
Because
why lawsuits settle now, don't
Yeah,
you?
and it's not.
It's nerve-wracking.
Yeah, let me tell you something. I won, but I didn't feel like running my hand in there and running down the road with no shirt on. I can tell you, because you don't feel like
That's
you
what
won.
winning feels like to him.
Yeah,
Clearly. He's
that's
telling
right.
us.
Yeah, I mean, if I won today, I'm gonna
told
take
you
that
what
shirt
he
off, take
told me.
off
I
right
said,
down the road.
Chris, just think you didn't have to pay him anything for that easement.
And it's right.
$25,000.
Yeah.
And things wind up working good on the deal. It wound up working out really good, and to say the future of it. But it was just, I always wondered in my mind, Jay, if it wasn't, but it was 275 acres and it had $500,000 worth of hardwood timber on it. Okay, just think if it was just a cutover, 80 acres of 60 acres. I mean, it'd be. You got to kind of weigh the odds of the fight, and if you ain't got, and there's some people out there, and I wish I didn't have it in me, but if you ain't got the fight in you, it may not be something you want to do,
Yeah, because it's confrontation.
It is.
It can be.
It's a
like I said,
problem.
when we very
Yeah.
first started, though, you never know, and you just got to hope that the people on the other side are reasonable and understand.
I got
Or
to
that
tell
they're
one
getting good advice.
I got to tell
And
Uncle
look,
Chris story because Jay
That reminds-
got on my butt. He kind of got killed, but they had a expert witness on there, and boy, they had this highfalutin attorney, and boy, he was big shot and spinning his phone. So I'm listening. So Jay, they put a expert on there, and Jay tore his rear end out. Really, he tore him up so bad that the judge said, "Listen, you may be an expert in your field, but you're not in this case.
I'm sure you are an expert.
Yeah, he said, I'm sure you are, but in this case, you're not.
You're free to
And
go.
you're free to go." And that guy said, "Oh, thank you, Judge."
Oh, he took it.
Yeah, he made him get down.
He just didn't take any of it. I mean,
And
told
when he
him to
got
get-
down, I looked over there at the other side, the lawyer and the guy was looking, and I went,
Oh, God.
and Jay bumped me and said, "Man, don't do that." And
I turned around and some little witness coming down. The expert comes down off the stand. He's looking at me, and I felt kind of bad. We're doing our job. And
I mean, he
completely
destroyed him.
discredited him.
Yeah.
That's what the judge said.
Yeah.
He said, "I'm sure you're an expert in your field." He said, "But on this particular case, you have been completely discredited. You're free to leave." And so the guy looks around like he didn't know what he meant, and the judge says, "You can leave." So we got a courtroom, with attorneys.
He's gotta walk
paralegals.
by everybody.
So he comes walking past me, and he's like smiling. I was like, "Thank you," and he's like, "Bye." And he looks at the other table over there, their attorney and the other party.
And that guy's puking in his shirt over
there about to melt. And I turn around to come sit back down at our table, and Herring's over here giving the choke sign at the other side. I'm like, no.
Oh, Hulk, when old Hulk, we got to talk about Hulk. When old Hulk would put that old hanger up. 1, 2. I mean, that's it. But it was
It was a comedy. It shouldn't have been. It wasn't funny. The issues weren't funny, but the other side brought in an expert witness. It was some kid about 26, 27 years old that testified that if Chris Herring drove his truck through there, it would disturb the game. But if other people drove through there that owned the property or his guests were hunting, that it wouldn't bother them.
Oh,
yeah.
Yeah, and testified this stuff. And I mean, it was.
And our judge.
have he ever seen you drive? Now he might have a point.
Yeah, but
shoot,
I mean,
deer be thinking Chris's truck full of corn.
Yeah,
He'll be coming.
I'd have one of them Texas style things on the front.
Yeah,
but
attract them.
Yeah. God, Jay, it's been almost 15 years.
A long time.
15 years ago, man. And but regurgitating that when Jay come in, that was a lot. You learn life lessons. You hear that. And that was a life lesson to being a land and timber.
And most people aren't going to run into that. Yeah,
and most of them settle. A good lawyer, and like Jay said, I'm going to tell you this to tip a lawyer. If they got a pretty decent lawyer on the other side that your lawyer could communicate with, say, hey, man, law's on our side. Okay?
Yeah.
Law's on our side. And
but a lot of times, which is just the nature of buying and selling land. You said something earlier that kind of triggered, kind of how you approach or how you talk to that landowner that you're going to have to ask for access. You can't do a lot of that up front because a lot of these land deals, you risk too much of tanking your deal. Mm-hmm. So and that's what creates some of that contention sometimes is you can't show your hand and you can't go ask too many questions even at the courthouse. Be careful. You know what I mean?
You always got the chirper in there.
You got to be careful. And
I'm hoping
it
right
pays.
now the other attorney on this doesn't watch some podcast and somebody tell them about they'll know exactly.
Look, I can promise you, I know him. He ain't.
Yeah, well, look,
he's a good lawyer.
Yeah,
I think his client just dug his heels in and said, "I'm not going to give up."
When you're charging $300-400 an hour, and he says, "Do what you take to keep him out of there." Remember, that's what he told me. So I'll spend what it takes to keep you out of there. That's what he told me. And I told him, I said, look, man, let me just tell you this. You're not from here, and I am. I'm getting to my land, I can promise you. He blocked it with remember all that old junk. And
that's a good kind of lawsuit, though, to try as the plaintiff's attorney as an access on a landlocked property because you know your client's going to get access. You tell them you won no matter what.
Yeah.
You're going to get there.
You're going to get access.
You're going to get access.
You're right.
Well, the thing it's just you need to be, as a prospective buyer, you need to read up on it. You need to know going in so you don't have to ask a lot of questions. You know what your move is going to be if you have to, because you can't ask a lot of questions on the front end before you buy one because that neighbor might buy it.
Look, don't jump in at the cheap price, because that $700 an acre landlocked 80 may go to $2,800, $5,000 an acre by the time you get through trying it.
And Brent, for your business, if you got not whoever's checking the title, if y'all you got representing a buyer, and they may have their bank or they may have somebody that they want to use to check the title, and when they're looking. If you didn't already know that it's landlocked, or if you looked at it before and you already know it's landlocked, you may want to tell their abstractor, hey, go on back
a little farther
if you need to.
That's a good
to
point.
Find out
try to get implied
if this little piece was ever part
of an original
tract. A bigger tract that has access.
Do that on the front end on the title.
On the front end, and that way you
got that much research.
And then you know which landowner you need to talk to instead of talking to all the other ones. And then it gets bound into the reasonableness of that adjoining property owner, and you go talk to them and say, look,
because I'm going to tell you something now.
Here's when this tract was all owned by X.
Because that's the home run for Axon landlocked. That's the one you want to establish.
Here's when they severed
that's the play.
at 40. Yeah. And so when that happened, as a matter of law, by operation of law, an easement was created across your tract.
Yeah.
And so we're going to need to come across your tract, but what we want to do is we want to ask you where you want that access to be. And I would even say you don't have to pay for it if you litigate it, but I mean, still, as a good neighbor, I'd say, look, where do you want it?
Yeah.
And I'll give you $1,500 or something, depending on how far you got to go. But
relative to what it would cost you to litigate it, that's what you got to keep in mind.
Hey, and roads ain't cheap to build either.
Yeah.
Roads ain't cheap to build.
That's right.
I mean, everything's high. Yeah. Jay, you remember the one track that the river cut in half for one of our Leslie Williamson owned? Remember the river cut one in 30 acres on one side.
Waterway project.
And 80 was on the other side, and then the guy was claiming it and put green fields and roads. And remember I said, hey, man, remember that guy, you had to go up there. We had to go up there, and he hired an attorney from Tupelo, a female attorney, remember? And he tried to claim adverse possession.
Just one of those forgotten memories.
No, but remember he tried to claim adverse possession on it.
This one don't forget
and his possession was, I've been deer hunting it. Well, we found the landlines, and the river went on both sides. And anyway, we had to make that guy buy it from us. We pushed him, and that girl said,
There never was a lawsuit.
No, but they were trying to claim adverse possession on, hell, I think it's like 45 acres. And just because, they put green fields and roads and shooting houses and
living it up.
Yeah, living it up. And we got Jay involved.
I forgot that one.
And we went in, and I remember it like it's yesterday, because we went in there and we sent letters back and forth, and we threatened anyway the guy wanted buying.
That's before every landowner, everybody had that on X.
Oh, man, that clears a lot of it.
Where you don't forget about.
But the river, we was talking about the river. The river separated it, cut through it. And but man, this guy, and he'd been using it for years. and that's when Aubrey said, it's hard to. Aubrey always told us, and he said, hard to adverse possession one just because you're deer hunting it.
Yeah, and so for context, somebody's not from this regionally. There's interest in the Tin-Tom Waterway. When they came through and cut the Tin-Tom Waterway, the Tom Bigby River used to meander through here, and they when they cut it out, it divided a lot of property. So that's how that
and that worked the same way. That's what it was, the old Tin-Tom.
Yeah, that's what I'm saying. Yeah. That's how that happened. You got the meander of the river, and they cut the waterway, so you severed it.
We said we wasn't going to say no names. I'll tell you the name when we get off air, and you'll remember it.
That one. I'm just thinking about what you were saying, though. What Aubrey was talking about, the continuous element of the adverse possession would be one there is going in and deer hunting from November to January.
Not continuous use.
Continuous use.
Yeah.
If you're going in there and planting and doing and bush hogging and keeping up.
And did somebody give you permission to go hunt?
And burning,
and
spraying the whole, cutting and doing, it may get something. But if you just go in there and hunt. But if other people know about it and they're hunting it too, then,
they could have claim.
Yeah.
Yeah.
It's also not exclusive,
It becomes public. I mean, really.
It's hostile then.
Yeah.
You got other people doing it too.
Yeah. Especially if you got a big deer on camera and somebody's in there hunting it.
You got turkeys.
It becomes hostile.
It's that way now on property where there's not any dispute about who owns it.
Jay, before we get out of here, what's our turkey hunting story? What's our best turkey hunting story that you could think, a quick one over the years that we hunted? What's a good one? I remember the one where Aubrey shot the one like the Indian. that was a cool one.
I'm trying to think.
And then the one coming over with the fan coming over that sun over them.
That we shot in the face at about 4 steps.
Yes, it come over them terraces over on Bishop Bottom.
Bottom.
That thing gobbled.
And think what
he
we
come
did
over
in
the
Nebraska.
Top. We did bad stuff in Nebraska. Probably don't need to talk about, but
I think one of the better ones in
Were
Nebraska.
you in the El Camino?
No, the El Camino was the day before we got there.
Yeah.
But I'll tell this one, and it involved one of our buddies that was the funny part of it. But there was a big turkey up there that the property owner had seen. We all wanted to kill a Merriam, but there really was Rios and hybrids
and
up
mixed
there. They all
jobs.
looked like Rios, but there was one here, remember?
Frosty?
Snowball,
yeah.
And he said, well, we got one over here called Snowball, yada, yada, yada. Well, Chris and Coates, we got the guy to take us, and I had to ride with the landowner.
Blowhard.
And I figured that deal out pretty quick.
Yeah,
I knew that Coates was involved in that. They said, let us out over here, and they're going to go down in the timber because they knew where the turkeys had roosted. And the property owner said, I'm going to take you. He comes out in this field every day, and and I ride with the owner, and he lets me out, and I can see good, but
that joker can see now.
I could see 3/4 of a mile to the timber where the turkeys were, and he said, "You just stay here." And I'm thinking, man, if you just please leave so I can get where
closer.
I need to get.
That's right.
Yeah.
And all I'm thinking the whole time is Herring and Coates are already down there in the woods going in the woods. Well, as soon as he left, I took off across that field, and I think I walked half a mile, and I could find one cedar tree that not as big as a couch, and I sat down in the middle of it and sat. And sure enough, turkeys gobbled daylight, and they pitched down. I was calling, and I'm sure we were far enough apart I couldn't hear them, but Snowball and his buddies came my way and didn't make it. I killed Snowball, but the funny part of the story is I don't know, when you said we did bad things, I don't know how many that made total at that time for the three of us. But I put my gun in the truck after that morning, and I said, "All right, I'm not killing any more turkeys."
Yeah,
I said, "We'll go." There was another,
because we was on Indian reservation, you could kill them. You know.
So the funny part is,
as long as you had $200.
That's a long intro to the funny part of the story. So we go, and there's another turkey gobbling on the other side of the farm, and we go as Coates and Herring and me, and I didn't have a gun. I'm gonna sit behind them. And we go, there's this hedgerow, and it's got some cedar trees on it, and the hedgerow stopped, and it kind of goes over a hill in front of us, and then there's a fence with little T-posts in front of us. And the turkey's gobbling down the hill. We can't see over the hill. Well, Chris goes up and sits at the T-post. I mean, he looked like an upside-down lollipop sitting there, and he's, I mean, literally now it's a T-post, and Herring is sitting there Indian style at this T-post looking over the hill. Well, Coates is sitting beside me at a cedar tree on his hedgerow, and we're about 20 yards behind Chris and off to his right a little bit. And the turkey's getting closer and closer and gobbling. He's coming up that hill, and for Chris, it'd have been off at Chris's probably 2 o'clock. It was straight in front of us. We didn't know if who's going to get the shot on him first. Well, Coates is sitting there next to me, and he's got his gun laid out at the end of this hedgerow, and there's a wire in front. If the camera's on me, I don't know. Coates is sitting there, and you see him. He says, I looked at him, and I said, "What are you doing?" He didn't say a word. I said, "Man, the turkey's fixing to pop up. You fixing to see him. You better be still." And, Coates is a good turkey hunter.
He is.
You don't have to tell him to be still. And he sat there for another minute, and he's got his gun up, and he says, and I looked at him. My eyes got big. He said, "That fence is hot, buddy." He said, "It'd like to knock my fillings out." He laid his gun barrel over on an electric fence. He got tired of holding it up, and he was holding it up, and it would dip, and it hit that fence. He said it nearly knocked his fillings out, and we got tickled, and we're sitting under the tree, and I'm laughing at Coates. And about that time, we never heard the turkey gobble again. And he got up close to the deal, and Chris stood up and came back, and he said, "I guess that some bitch saw y'all up over there." Chris at the top of the hill. It's like his grape coat sitting on this deer horn.
I blamed on y'all.
I think he saw y'all back there in those cedar trees.
You could get away with some stuff sometimes out there.
But the turkey lived for another day.
It was, but man, that was some good stuff. But
if you could see somebody lay a gun barrel on a hot fence when they not suspecting it, it's pretty funny.
Pretty hot.
Yeah, it was funny.
Whew, well,
That tickled me pretty bad. I can picture that.
And Coates a big boy. He's stout dude.
But
now.
what's funny is he stayed with it. He knew what happened. That's how important that turkey was. He stayed with it.
Let me tell you something. As much as he loves to kill a turkey, he could bite it. If he knew he could shoot it,
right.
He'd bite the fence and then shoot it. But
no question.
He's that was some good. That was some good.
Oh man,
that was good stuff.
All right, so look, that's a lot of good information. This, like I said, easements and landlocked properties there's a lot of misconceptions, and there's a lot you need to know going in. I mean, and look, you can buy them; they can be bought, and there's a lot of good landlocked properties.
If you like to gamble, that's exactly what you're doing. I must tell you, when you buy one and don't know the backstory,
it's not a gamble of if you're going to get to it. It's a gamble of how much extra it's going to cost.
That's right. That's correct. I've never had one say, "Hey, man, let me just give you an easement."
Well, here's one aspect. I know we need to wind it up, but we didn't talk about this. A lot of those landowners that you have to go through are keenly aware of that situation. And they may say, "You got this for $700 an acre because you don't have access. So I'll give you an access. But guess what it's going to cost you?
It's going to cost you.
It's going to run at value.
Give me $25,000 and I'll deed you an easement or something like that."
Yeah.
But they know, a lot of them.
Yeah, they do.
And look, if property's worth it. I mean, that's part of the cost.
Yeah.
You know, you saved it on the front end, and just as long as you know, as long as you're an informed consumer.
Yeah.
That's
That's
it.
All right, y'all.
All right.
Until
Well,
next
that was
time.
a good one.
Enjoy
Appreciate
it,
it.
fellas.
Yes, sir.